One of the most notable court dramas in recent memory centres around the Oscar Pistorius case, a gripping saga that has captured international attention and ignited impassioned debates on justice, guilt and rehabilitation. As the date of January 5th, 2024 approaches, Oscar Pistorius' potential parole consideration raises significant concerns about atonement, second chances, and the rehabilitation of individuals who have committed serious crimes. Oscar Pistorius, a former Olympic and Paralympian athlete from South Africa, was convicted of killing his girlfriend Reeva Steenkamp on Valentine's Day in 2013. Subsequently, Pistorius was incarcerated following a trial that garnered global interest. The impending eligibility for parole in January 2024 has sparked discussions about Pistorius' potential reintegration into society. This introduction establishes the context for a nuanced analysis of his release on parole, delving into various relevant issues such as rehabilitation initiatives, remorse, and the broader impacts of the legal system. Join us as we explore the intricacies of this case and speculate on the possibility of a redemption journey for one of the most watched sportsmen in history. 10 years ago, in the pre-dawn hours of Thursday, 14th of February 2013, the narrative of Oscar Pistorius, the renowned South African Paralympic athlete, shifted dramatically. The tranquility of his home in Pretoria was shattered as a single gunshot echoed through the corridors, forever altering the course of his life. Tragically, the victim was his girlfriend, Reeva Steenkamp. This fateful incident marked the inception of a gripping and profoundly tragic tale. Oscar Pistorius, celebrated for his achievements in overcoming physical challenges to become a global sports icon, found himself thrust into an unforeseen spotlight. As the initial details emerged, Pistorius admitted to firing the fatal shot, but he maintained that it was a heart-wrenching mistake. His claim asserted that, in the darkness of the night, he believed that Steenkamp was an intruder, a misjudgment that would become the epicenter of a legal saga destined to captivate the attention of the entire world. The murder trial of Pistorius commenced on the 3rd of March 2014, unfolding in the Pretoria High Court. The proceedings underwent intense scrutiny as the athlete faced charges of premeditated murder for the shooting of Reeva Steenkamp. The trial, initially scheduled to conclude on the 8th of August, took an unexpected turn when forensic psychiatrist Meryl Vorster diagnosed Pistorius with generalized anxiety disorder. This revelation prompted the prosecution, led by Jerry Nell, to request a psychiatric evaluation to determine Pistorius' mental state at the time of the shooting. Judge Thokozile Masipa granted the request, resulting in a temporary adjournment of the trial until 30th of June 2014. The purpose of the evaluation was to establish whether Pistorius could be held criminally responsible for Steenkamp's death. On the 30th of June 2014, the trial resumed after psychiatric evaluations concluded that Pistorius was fit to stand trial. The defence closed its case on the 8th of July, and closing arguments were heard on the 7th and the 8th of August. The trial's focal point was whether Pistorius' actions were premeditated or a result of genuine fear, with the defence arguing the latter. On September the 12th, 2014, Judge Masipa delivered a verdict that sent shockwaves through the public. Pistorius was found guilty of culpable homicide, a lesser charge than premeditated murder, and a firearm-related charge of reckless endangerment. However, he was acquitted of other firearm-related charges. The court sentenced him to a maximum of 5 years for culpable homicide and a concurrent 3-year suspended sentence for reckless endangerment. In June 2015, Oscar Pistorius became eligible for early release from prison after serving a sixth of his sentence. This marked a crucial juncture in the high-profile case that had captivated the world's attention. The South African Commissioner of Correctional Services, Zak Modise, made a significant announcement during this period, revealing the potential release of Pistorius under the designation of correctional supervision as early as August 2015. The decision to consider early release was grounded in an assessment of Pistorius' behaviour during his time in prison, affirming that he displayed good conduct and posed no discernible threat to the community. As news of Pistorius' potential early release circulated, it stirred both public interest and controversy. People closely followed the developments, curious about the legal process and criteria that determined the feasibility of such a release. The prospect of a high-profile figure like Pistorius returning to society raised questions about the nature of rehabilitation, justice, and the impact of a celebrity status on legal outcomes. However, the anticipated release faced an unexpected hurdle just days before its scheduled occurrence on the 21st of August 2015. South Africa's Justice Minister, Michael Masutha, intervened and decided to block Pistorius' release. Masutha characterised the decision of the parole board as premature, introducing an element of uncertainty and controversy into the already complex narrative surrounding this case. This move by the Justice Minister sparked debates about the discretion and authority wielded by governmental officials in matters of early release and parole, particularly in cases with considerable public attention. Following the ministerial intervention, Pistorius' release was delayed, prompting further legal developments and heightened public scrutiny. The incident added layers of complexity to the ongoing discourse on justice, punishment, and rehabilitation within the South African legal system. Ultimately, Oscar Pistorius was released from prison on the 19th of October 2015, marking the culmination of a series of legal twists and public debates that surrounded his eligibility for early release. In the aftermath of the trial, prosecutors sought to challenge the culpable homicide verdict, deeming the 5-year prison term shockingly light. On December 10, 2014, Judge Masipho ruled that the prosecution could appeal the verdict but not the length of the sentence. Subsequently, the case was scheduled for an appeal at the Supreme Court of Appeal. The appeal, set for November 2015, centered on the legal principle of dolus eventualis, whether Pistorius should have foreseen the consequences of his actions. Prosecutors argued that Judge Masipho erred in determining that Pistorius did not foresee the potential harm caused by firing 4 shots through the closed toilet door. On the 8th of December 2015, an announcement was made that Pistorius would remain free on bail but under house arrest. This status persisted as he awaited further legal proceedings. In a subsequent attempt to appeal, Pistorius sought to challenge the murder conviction. On the 3rd of March 2016, his right to appeal was denied, and the focus shifted to the sentencing hearing for the murder conviction scheduled for June 2016. On the 6th of July 2016, Judge Masipho sentenced Pistorius to 6 years in prison for murder, an increase from the original 5-year term for culpable homicide. Pistorius returned to Kosi Maperu jail, where he was expected to be eligible for parole in 2019, having served 3 years of his sentence. In August 2016, Pistorius made headlines when he was treated at Kalafong Hospital after sustaining minor injuries to his wrist in what his brother, Carl, stated was an accidental cell slip. The National Prosecuting Authority found the 6-year sentence to be shockingly lenient and sought to appeal. Despite Pistorius' status as a model prisoner, the parole board denied his release. The Steenkamp family's lawyer confirmed the denial, with the possibility of reconsideration in 1 year. The legal saga continued in September 2017 when the Supreme Court of Appeal agreed to hear arguments to extend Pistorius' sentence. On the 24th of November 2017, the SCA ruled to increase Pistorius' sentence to 13 years and 5 months, deeming the initial 6-year term inadequate. This decision marked a significant development, effectively closing another chapter in the protracted legal battle. Despite the increased sentence, Pistorius sought to challenge the decision by filing papers with the Constitutional Court to appeal the extended sentence and revert to the initial 6-year term. On the 9th of April 2018, the courts dismissed his appeal, confirming that Pistorius would not be eligible for parole until at least 2023. As the parole date of January 5, 2024 approaches for the former Paralympic champion Oscar Pistorius, the world watches with a mix of anticipation and skepticism. Nearly 11 years have elapsed since Pistorius was sentenced to 13 years in prison for the 2013 murder of his girlfriend Reeva Steenkamp. Pistorius, now 37, had contended that he mistakenly believed Steenkamp was an intruder when he fired fatal shots through a bathroom door on Valentine's Day. The parole decision has not been without controversy, notably fueled by concerns expressed by Steenkamp's mother, June, about Pistorius' unresolved anger issues. In a poignant letter to the parole board, June Steenkamp questioned whether these issues had been adequately addressed during his incarceration. The absence of June Steenkamp from the recent parole hearing at Attridgeville Prison near Pretoria adds an emotional layer to the unfolding narrative. Her decision, attributed to the profound strain following her husband Barry's death earlier in the year, highlights the enduring impact of the tragedy on the Steenkamp family. As the world awaits Pistorius' potential release, the parole decision prompts a reassessment of the intricacies surrounding rehabilitation, public safety, and the quest for justice in a case that has captured global attention for over a decade.